2808. It was called to discuss the Cablevision contract. A number of other items have been added to the agenda. Roger Connor, the individual from Cablevision, has called and said he's tied up in traffic. Where's Ross?
Pardon me? Yeah, I was going to say Ross was making copies, I think.
So we'll wait for Ross. We'll call the meeting to order. As I was saying, Roger Connor from Cablevision is tied up in traffic. His item was the first one on the agenda. In his absence, we'll proceed to the second item. No, not the special round. We'll move to the intermunicipal agreement. This is an initiative that was started last year. Glenn Butler attended a meeting in Dover. It involves a number of towns in Dutchess County. The purpose of the intermunicipal agreement is to facilitate preparation of a multi-hazard mitigation plan that will cover the participating communities using grant funds awarded by FEMA. And I have a contract here. It's been reviewed by the attorney. She's made changes which the parent organization has accepted. I'm ready to sign the contract given the approval of the board. The cost is $16,000 per year, $4,000 per quarter, and the idea is to front the $4,000 and quarterly the $4,000 will be reimbursed and rolled over so that the net cost to the town would not be $16,000 but only $4,000 at risk. So I need a motion to accept the contract.
I so move. I'll second.
Any discussion? Call the roll.
Aye.
Aye. Aye.
Aye.
Aye. The next item is a consideration of a mild injustice court grant Justice Christensen applied for and received $24,000 in state funding from the Justice Court Assistance Program. And it involves security system for the court, new seating for the court. These new chairs will be interlocking so that individuals can't pick them up and use them as a weapon. There'll be a variety of other improvements to the court. There'll be a door constructed downstairs, disallowing access from the lower level to the backside of the courtroom and the judges' chambers. But what Frank has given me here is an expenditure of $6,320 of the initial grant to purchase 64 chairs to be used in the courtroom. These chairs are being purchased because of a security check done by the Unified Court System Department of Public Safety. The inspection was done on the operation and security of the Milan Justice Court. So what Frank wants to do is, of the appropriation submitted to us from the state, he wants to expend $6,320 for chairs.
So moved.
Chairs.
I'll second.
Any discussion?
What was his grant?
The grant, the grant, a total grant was $29,543. We received about $24,000 and some odd of that money.
We could make a motion to transfer that into the contractual line first, if you like.
Yes, I'd like to do that.
Right, so can we?
Well, we'll accept this motion and then we'll make the transfer. So let's call the roll and then we'll make the
Okay,
funds
it's
transfer.
been motion and seconded, and I say aye.
Aye. Aye.
Aye.
Aye.
Okay, and also we need to make a motion to transfer $24,700 to 110.4 judges contractual line for the sole purpose of the judge security grant. Do you have a second?
Second.
Discussion. Call the roll.
Aye.
Aye. Aye.
Aye.
Aye. Okay, that takes care of that. No Roger Connor. What did you want to do now?
Okay.
Attorney-client
yeah,
session?
If we're ready, I'd like to move into attorney-client session to review some changes to the resolutions for tonight, and also just to discuss strategy, legal strategy for the evening and going forward. I think it'll be very short.
Okay. Any discussion?
Is that a motion? I'll second it. Any discussion?
Discussion, none? Call the roll.
Aye.
Aye. Aye.
Aye.
Aye. Do you need copies of the old motions?
I've got stuff.
You got the new one?
Yeah, but you can tell everybody to bring the motions with us.
Some litigation against the town, and we were hard pressed to decide whether or not to appeal, given the lack of funding in the budget. But since then, it's come to our attention that since we are members of the Greenway Pact, that the state of New York will indemnify members of the compact against challenges to its land use regulation. And that will be the basis of the funding for the appeal for these lawsuits. We've split out the issues.
We better wait for Ben.
Everybody stand down here.
And we're just Mickey Mouse slippers. We've split the issues thusly. The comp plan, the floating light industrial zone, the wetlands law with respect to Woodwing, and the wetlands law with respect to 1133 Taconic. And the first issue will be the appeal of the comprehensive plan. David?
Yeah, I'll go ahead and read this resolution to file a notice of appeal for the comprehensive plan. Whereas the town of Mylan did adopt a comprehensive plan in 2007, the town was sued by the Red Wing Properties Incorporated with respect to these actions, which has resulted in a ruling on March 24, 2008 that said actions are null and void and the granting of an injunction against their enforcement. And the town board, upon advice of its attorneys, believing this decision to contain material errors of fact and law with respect to the conclusions reached on this action. Now therefore, the town board of the town of Mylan hereby resolves to authorize the filing of a notice of appeal with respect to the decision in Red Wing Properties v. Mylan, case index number 7379/2007, as it pertains to the town of Mylan Comprehensive Plan 2007, and further authorizes the filing of a motion to stay the injunction imposed by the Supreme Court in the event such stay is not automatic.
A second.
Any discussion?
Actually, I have a statement, but my statement involves all of the laws. Should I just read it at the beginning or at the end? I'm not really sure.
Do you want to have any effect on the voting, or you just want to make a statement?
Well, I don't think I'll have any effect on the voting, but maybe I should just read it now then, so that it's on the record, and then we can vote on this first motion,
Okay.
if that's okay. I'll stand, because my voice doesn't carry very well, and I want to thank everybody that sent me correspondence and my email. I do have a slight computer virus now, but I will try to fix it as soon as possible. But I do appreciate your sending me that correspondence. I really believe in the First Amendment, freedom of speech, and a lot of other freedoms, one of which is to be rural and free in Mylan. My public comments regarding the comp plan resolution in wetlands law, local number 7, are well known. In fact, my opponents used my comments against me when I ran for town council last year. Despite my public and private opposition to the comp plan and wetlands law, I received over 60% of the vote, and here I am today. That overwhelming victory indicates to me that the majority of residents in Mylan were seeking a change, and they agreed with what I had to say. I have several major issues regarding the 2007 comp plan. The plan fails to address market trends, and that should be obvious to everyone at this point given the current state of the housing industry. Since I wrote my comments regarding the DGEIS last year, almost about a year ago to date, the housing market has slipped even further. According to the Mid-Hudson MLS, closed sales are down 39% from 1 year ago in Dutchess County. Creation of the rural space overlay zone has significant shortcomings and should not be used to support drastic zoning regulations before considering alternative open space techniques. And the public opinion survey conducted in June of 2000 was cited as one of the main criteria used for expressing the town residents' wishes and to define town policies for preservation and growth. The future planning of our town has been based on 10 simple, unqualified questions and a slideshow presented to 50 people in September of 2000. The objectives of this survey were sincere, but the hard questions were never asked. The community preference choices previewed at that time were either good or bad, yes or no. That is not enough to base the future of our community on. The knowledge that this comp plan is not set in stone gives me a lot of hope that it can be modified as soon as possible. I look forward to a collaborative effort that will make this a better document for all of our residents going forward. Regarding local law number 6, the elimination of the floating light industrial zone, I've also stated in the past that everyone has a need for gravel, and they do. Most driveways in Mylan are made of gravel. Mining is and always has been a rural enterprise. However, gravel mining is not wanted in Mylan for many reasons. The citizens of Mylan must realize that given the limited resources available to our town, we will all have to make sacrifices and reduce services to continue this fight. And perhaps with the Greenway issue, we might be able to get some funding from that avenue as well. The 2008 budget we inherited, unfortunately, did not allocate sufficient funds for this litigation or any other lawsuits that result because of this action. Last year at the DEC hearing on the Red Wing Mine permit, I recall a room full of people, mostly in opposition, including myself. I know you will all put your money where your mouth is when the time comes to raise funds if needed in order to go forward with this appeal. So I've given this decision a lot of thought, and I suppose we can vote on it now one by one, but I will add that I did campaign wholeheartedly against local law number 7, the Wetlands and Water Courses Law, for a variety of reasons, and I cannot and will not support any appeal for that law. Thank you.
I just want to comment on the RSO as well. I have a problem with RSO, as I've stated before. Dividing land into large lots, of course, increases the value and makes it harder for moderate income families to live in the area. It's going to change the demographics. Also, the comp plan argues that the RSO will discourage families with children from living in the area because of that same reason. And because it will reduce families with children, it will help keep school taxes in line. The problem is you increase the values of lots, you reduce the number of students, that decreases state aid. So it basically negates that proposed effect. So I think the true economic impact is unknown. So again, I think young families and moderate income people should live in this area. I think young families help keep the community vibrant, and we need a diverse community. And that's my issue, my main issue with the comp plan. But I understand that also, in order to help the fight against mining, that can be passed.
I'm next.
You want to go next? Go ahead.
I have issues with the comp plan, the rural space overlay, the planned purpose development. I think the build-out figures are wrong. However, we have supported Milan Concern's appeal against Red Wing with the DEC. And for me, not to support the comp plan at this time and the FLIZ, in my view, would weaken the case against Red Wing versus Milan versus the DEC. And I don't want to do that. I ran on a platform that was against mining, and I'm against mining, in spite of what some people think and have to say. On the other hand, the Wetlands and Water Courses Law, I also campaigned against that. I said that was regulatory taking, and I still feel that way. I guess you can determine what my vote will be based on my statement. Ross.
Well, I think what I'm going to lay out what my comments are. I did send an open letter to the board, which was made available to the community as well. And I would just highlight a few of those things that were in that. I think that we have today a very strong set of documentation of our comprehensive plan, of the elimination of the floating light industrial zone, of our wetlands law. I think they have all been done right. There are, I will readily acknowledge, issues among the board and in the community on the comprehensive plan and some elements of it. And I think those can be appropriately addressed through amendment of the plan. And for example, with respect to the rural space overlay zone, I mean, I think there's a good reason why the last town board did not bring that back to the table. And that was, it was pretty clear that there was a strong outcry against it. I do think there are other options of ways that we can protect open space in Milan, that we can keep Milan open. We identified some of those in the open space report that was done last fall or last year and turned into the board. So I believe that for today, we have a very strong comprehensive plan backed up by an FGEIS, a final generic environmental impact statement. that stands us in very good stead as we then go forward on appeal of the comprehensive plan. It similarly sets the base for the appeal relative to the elimination of the floating light industrial zone, which I believe is, those two things go hand in hand, and without one, we don't have the other. So we need to do that. I also believe that with respect to the wetlands law, that we should appeal that. And again, I know there are issues with my fellow board members about the wetlands law and some of the provisions of the law or the law itself. As I outlined in this open letter to the board, that law is not intended to prevent development. It is intended to protect our water resources. It will not, in my opinion, prevent development. And I've talked a little bit with some of my fellow board members about that. On the other hand, maybe there are things in there that are more restrictive than the town would like. I'm not sure what they are. I think reasonable people may debate that. But the way to correct that is through the legislative process, not by rolling over in the face of a court opinion, particularly a court opinion as bad as this one is. There are a number of reasons why I believe we should appeal the wetlands rule. The first is that the judge uses a standard of least restrictive means, which is an inappropriate standard for land use law. Second, the ruling tends to indicate that seeker needs to balance the environment against the impact on development. That is wrong. That is not the seeker law in New York State. And third, we have seen that the Durst Corporation has a strong propensity to get whatever they want. And they do it with a heavy foot, and they do it through lawsuits. They've done it with McEnroe Farms over in Armenia. They filed a tax certiorari case against the town of Milan when they first bought the property that's still open. Now they've sued us on wetlands. They will continue to sue. And I believe for this town to give up, in effect, its home rule rights, in this case, where the standard is set wrong by the judge, the case is simply an atrocious case from the standpoint of standing up on appeal. And I believe that to roll over now threatens continuing litigation, not only for us, but for our fellow communities in Dutchess County. This is a bad decision, and we should appeal it. And if we need to change the wetlands law or repeal the wetlands law, then that's what we should do. But we should not abandon appeal on this law. That's it.
Thank you. Diane?
Yeah, I'll just, my main issue with appealing, the need to appeal, and political views aside, gravel aside, overdevelopment aside, it's the home rule issue that is the most important thing that we need to address here. That's why we need to appeal both decisions on all four issues. The comprehensive plan, the elimination of the floating and light industrial zone, and the wetlands water courses for both the Durst and for Red Wing. It's the home rule issue. We should decide what we want and don't want for our town, not a judge in the state court. Self-determination, I believe, no matter what your view is or what your political persuasion is, I believe is something that we all value, and that's the thing that we need to act on, is we decide what we want for our town, not a judge. And I think it's very important that we file that notice of appeal on all the issues. And as Ross suggested, if we as a town decide we want to amend our own laws or correct or change or amend our comprehensive plan, then that's what we do. We don't have the court do it. And once we let this go, this will be the precedent that then is set for our town, for our other communities, other municipalities, and we have lost all control over our future, what we want to do for our town, and I think it's very important that we file that notice of appeal.
Thank you. So we have a motion.
And a second? I'll second.
That was all of our discussion. Call the roll.
No.
Aye.
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 Aye. David, would you, no, Bobby, would you do the FLIZ?
I'll try. Lost your handwriting. Okay, let's see if I can get this right. Whereas the town of Milan did adopt a comprehensive plan, and further the town did enact consistent with that kind of local zoning law entitled Elimination of the Floating Light Industrial Zone. The town was sued by Redland Properties, Inc. with respect to the elimination of the Floating Light Industrial Zone, Local Law Number 6, which has resulted in a ruling on March 24, 2008. That said actions are null and void, and granting of an injunction against its enforcement. The town board, upon advice of its attorneys, believes its decision to contain material errors in fact and law with respect to the conclusion reached on this action. Keep going? More?
Well, the statement regarding authorizing the law firm.
It's crossed out. Okay.
Yeah.
All right, the town board of the town of Milan hereby resolves to file the appropriate notice of intent to appeal the New York State Supreme Court decision finding the Milan Local Law Number 6 of 2007, elimination of the floating light industrial zone null and void in the matters of Redwood Properties, Inc. versus the town of Milan, index number 7379/2007, and to further authorize the filing of a motion to stay the injunction imposed by the Supreme Court in the event such stay is not automatic. I so move.
Second.
If I might, I'd like to modify the resolution, Bobby, just.
Did I screw it up?
Well, you left out the elimination of the floating light industrial zone in the second line and said this action, and I just think it needs to be specific.
I thought I did say it.
You
So which paragraph
first
is
line.
Russ?
If I could read paragraph 2.
The
The
town
town,
was,
yeah,
go ahead. The town was sued by the Redwing Properties, Inc. with respect to the elimination of the floating light industrial zone, which
Right.
has resulted in a ruling on March 24th, blah, 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 blah.
Yeah. Okay. Right.
Any further discussion?
Now, Bobby, I lost track. Did you do the now therefore from the page that says number 2 on it? Now therefore number 2?
That's number 2.
Well, I have two number twos.
Yeah.
This one here?
This one.
I think she gave us the wrong.
Yeah, those, number 2 was the
This top
first
part,
part,
number 2,
and
this
then
bottom
number
part.
2.
Okay, I apologize.
Right, each one.
I'll read this number 2 as well. The town board of the town of Milan hereby resolves to authorize the filing of a notice of appeal with respect to the decision in Redwing Properties versus Milan case number 7379/2007 as it pertains to local law number 6/2007, elimination of the floating light industrial zone, and further authorizes the filing of a motion to stay the injunction imposed by the Supreme Court in the event such stay is not automatic. Okay? Should I make that motion again?
This is what we're working on.
Okay, I so move.
Second. Any discussion? Call the roll.
Aye.
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 Aye. Russ?
Okay, let's see. The town of Milan, whereas the town of Milan did adopt a comprehensive plan 2007, and further, the town did enact consistent with that plan a local law entitled Freshwater Wetlands and Watercourses Protection Law, and the town was sued by 1130 Bill, wrong one,
Not that easy, is it?
No.
Do you need a number 3?
Okay. Let me start over here. Whereas the town of Milan did adopt the comprehensive plan 2007, and further, the town did enact consistent with that plan a local law entitled Freshwater, Wetlands, and Watercourses Protection Law. The town was sued by Red Wing Properties with respect to the Freshwater, Wetlands, and Watercourses Protection Law, which has resulted in a ruling on March 24, 2008 that said actions are null and void and the granting of an injunction against their enforcement. The town board, upon advice of its attorneys, believes this decision to contain material errors of fact with respect to the conclusions reached on this action. Now, therefore, the town board of the town of Milan hereby resolves to authorize the filing of a notice of appeal with respect to the decision in Red Wing Properties versus Milan, case index number 7379/2007, as it pertains to local law number 7, Freshwater, Wetlands, and Watercourses Protection Law, and further authorizes the filing of a motion to stay the injunction imposed by the Supreme Court in the event such stay is not automatic. I so move.
I'll second.
Any discussion?
Yes, I'd like to discuss the wetlands law more before I just talked about the comp plan. I understand a lot of people put a lot of hard work into this, for the sake of the town. But as has been discussed earlier tonight, I think we need to listen to the people in town and what the people want, what the town wants. I'm speaking as someone who's been around and spoken to a couple hundred people, within the past 500 months during the campaign, and asked them how they feel about the wetlands law, how they feel about giving up some property rights for added protection of wetlands. And I'll tell you, most people are not willing to pay that price. And so my statement here just concerns what I see as people's reservations about the wetlands law, and they also reflect my reservations. First of all, people are concerned about how they feel that it disrespects the rights of property owners. For example, and this is hypothetical, if you have a 4-acre lot and you have wetlands going through the middle of 2 acres, there's a 100 feet buffer on either side. A square acre is 209 by 209 feet. That essentially can cut in half the amount of land that you can use without restriction on your property. That's a significant issue for a lot of people. Also, the construction of new structures being prohibited within wetlands. For example, these are examples people have given me. If you want to put up a little fence, like a hidden fence to prevent your dog from running into your neighbors, it's in wetlands, you can't do that. If you want to put up a gazebo, cannot do that. Another is clear cutting or removal of trees, shrubs, and other vegetation. The only time that you can do that is if there's existing landscaped areas and residential gardens, and you want to conduct normal maintenance. So it has to be existing. That means you can't do that unless you already have these landscaped areas, or if you want to restore the wetlands. Another issue was just dumping of biodegradable yard waste, like grass clippings. This is prohibited within the wetlands, not within the buffer zone. Also, a regulated act, this is not prohibited, but this is regulated within the wetlands. Any removal of soil, mud, sand, gravel, or any other earth materials. This includes removal of invasive plant species and revegetation. Again, that's a problem people had with this law, is that you can't weed out areas on your wetlands. So, people feel that it restricts their rights as property owners. It infringes on it. And also, they feel that it curtails their personal freedom as well. I know many people can debate about what it means to be rural and what the definition of that is. Everyone has their own viewpoint on that. But I personally think that a part of being rural is having personal freedom. And I'm talking to someone who's grown up in the country. Another concern is people do not want to be overregulated through added layers of what they consider bureaucracy. In this case, the town wetlands law, when it's applied, has to be more restrictive than the DEC wetlands laws and also the Army Corps of Engineers wetlands laws per Article 24 of the Environmental Conservation Law. So because of that, people see that it has to be more restrictive. It's going to be an added layer of bureaucracy. And in fact, that's true, as far as some of the prohibited acts within the regulated areas. For example, according to the town law, placement of any fill materials, soil, gravel, sand, wood chips, stones, solid waste, etc., is prohibited. According to U.S. Army Corps of Engineers, those are not prohibited but regulated. And I've talked with Ross about this briefly, but this was again raised in Judge Brand's decision as part of his rationale. And Ross and people say that the law intends to control the manner in which wetland areas are to be built, not prevent building. So, it's kind of confusing. As does it have to be prohibited, or if it's not to prevent building, and you have to bring building materials in, can it just be regulated? So anyway, regardless of what the real intent of that prohibition of fill materials is, the verbiage used by Army Corps of Engineers, in their New York Regulatory Program Guidebook says, discharges of fill material are regulated under Section 404 for all waters of the United States, regardless of size. So, regardless of the size of the wetlands, they have jurisdiction over it. So they claim that you have to go before the U.S. Army Corps of Engineers and apply, through a lot of paperwork, which is also redundant with the same paperwork you have to submit to the town, but then there's a lot of other additional paperwork which is different, and so again, it's bureaucratic to have to go through a joint application. And just building off what the Army Corps of Engineers go for as far as their criteria, their district commanders are required to consider all factors in the public interest, including economic development and environmental protection. So in summary, I just don't think that a hard look was really given to the impacts on economics in the area and also community character. People, in my view, do not want this.
Thank you. Anything else? Ross?
Yeah, I'm not going to revisit all of the wetlands rationale and some of here tonight. That's not the point. I mean, I do think there are huge. It's a very complex law, and it's based on science. There are a lot of misunderstandings, and David, with all due respect, a lot of inaccuracies in what David said. But again, I don't want to go into all of that tonight. We wouldn't have made a more restrictive law unless there was reason for a more restrictive law and support from the DEC and others that there is a need for more restrictive laws. There is one person in the Hudson Valley who works for the Army Corps of Engineers. One person. They do not do reviews. And if you want them to do a review, it's a year or more before they can get to your property. So there really are very good reasons for doing this, but let's put that aside. Obviously, we didn't do a good enough job of explaining to people why and how. But the issue for me is not, again, the wetlands law. We can change the law. We can even repeal the law. You have 3 votes sitting right here to repeal the law. I would suggest to you that you should do that, if that's what your inclination is to do. But you should appeal this ruling. And the reason you should appeal the ruling is, as Diane said, to protect our home rule rights. We have someone sitting down on the bench in Dutchess County who has, through misinterpretation of the law, stripped our town of its home rule rights. And we should not sit still for that. We should appeal, and we should win. And then if you want to appeal the law, be my guest. But don't do it now. Don't just say, this is the easy way to get rid of this law we don't like. I think that's the wrong course for this board to take.
Diane?
Well, yeah, I mean, again, and obviously to everybody, you know how this falls, but if David has a concern about personal freedom, then I would think that the last thing you want to do is let a judge decide and dictate what your personal freedom is. Why would you give that up to a judge? That is for us to control. We need to appeal. We stand a chance of recouping our expenses that we've incurred and going forward. File this notice of appeal, prevail, and then make amendments, repeal the law, you know, be proactive in that way, as opposed to just letting the court make your decision. I just think it's a terrible disservice to the town. And just to be clear, the judge who made this decision, we submitted over 3,000 pages of legal documents, box. He rendered a 5-page decision. And it was not based on, it was wrong, it was inaccurate. He didn't consider the town's documentation. So to let him stand, to let that to be the standard now for the town, I think is just a terrible mistake. That's not to say that we can't change our laws, amend them, remove them, but let us make that decision. Let's not let Judge Brands make that decision for us.
If I could make this, I forgot to say in my first set of comments, and again now, the standard that the judge used, which he particularly applied to the floating light industrial and the wetlands law, was, as I said earlier, the least restrictive means, which is an inappropriate standard. The right standard, we're told, is a rational relationship standard. Does what the town did bear a rational relationship? Did they give thought, and does it bear a rational relationship to the goal of the town? And by any standard, the FLI and the wetlands law would meet a rational relationship test. When I say that the judge is stripping us of our home rule rights, again, we have the right to determine what our goals are and to figure out how to address those goals. Under seeker and under state law, a judge is supposed to defer to those. He is not supposed to come up with a higher standard and make some decision for the town that we have the right to make. And that's what we're deferring to here. We're letting him make the decision for our town. And that, frankly, bothers me.
And I have to tell you, it's not just our right, it's our responsibility. I mean, that is our responsibility. We shouldn't give it up and give it over to another entity. I think that, again, it is just a disservice to the town, to the people of this town, to the surrounding communities.
I just want to add that, it's been implied that, the chances of success on this wetlands is great. I'm not going to get into specifics, but people need to know that there's varying, percentages of success for different appeals, and they're not all great. And, that's it.
And I just want to say, I don't know if you have to say anything as well, but I just want to say that you created this wetlands law against a lot of public opposition to it. I've been to many meetings. I don't think a lot of people were in favor of it, and you passed it anyway, with a lot of comments that were not favorable to it. And all I have to say is it's too little, too late. You shouldn't have passed the law in the first place. That's all I have to say.
I don't agree with that.
I do.
Be that as it may.
Yeah. We can all agree to disagree without being disagreeable. We were informed the wetlands law had the least possibility of surviving an appeal.
Let's cut it
But
off.
better than 50%.
Uh,
I think it's 50%.
I don't think we should be discussing percentages here.
I recall them saying it was about 50-50. And,
The reason being,
We talked about it in executive.
in any case, I think the wetlands law has been poorly drafted. I went door to door in this town. I campaigned against the wetlands law. I went to the public meetings. I spoke out against the wetlands law. I remember saying, this town may need a wetlands law, but not this law. And I'm glad to see it die a death if that's the decision that's made here tonight. There being no further discussion, we'll call the
Well, I
roll.
would just encourage you then to vote for it and we'll change the law.
Exactly,
We got a motion and a second?
to protect our water, our drinking
the
water.
motion is to appeal the decision? No.
No.
Yes.
Yes.
No.
Wrong, Dick.
Okay.
Wrong.
Okay.
Ross, will you sit with Darlene tomorrow and give her the language of all those what ifs and whereases?
Are you in tomorrow, Darrell?
Wednesday?
Friday, Wednesday.
Wednesday.
Sorry, this is Wednesday.
Yeah.
Because I want to be sure she gets that
Yep.
down specifically.
We have a fourth one.
Yeah, we need
Um,
to.
You want me to read it? Who's going to read it?
Sure.
Okay. Whereas the town of Milan did adopt a comprehensive plan, and further the town did enact consistent with that plan a local law entitled Freshwater Wetlands and Watercourses Protection Law. And the town was sued by 1133 Taconic et al. With respect to this law, which has resulted in a ruling that said action requires a de novo review of seeker. And the town board, upon advice of its attorneys, believes this decision to contain material errors of fact and law with respect to the Freshwater Wetlands and Watercourses Protection Law. Now therefore, the town board of the town of Milan hereby resolves to authorize the filing of a notice of appeal with respect to the decision in 1133 Taconic et al., case index number 7771/2007. Further, the town board authorizes the consolidation of this appeal with the appeal of case index number 7379/2007, if appropriate in the judgment of our attorneys. I so move.
I'll second.
Any discussion? Call the roll.
I would just like to point out that we are just, by having taken the action on freshwater wetlands over there, we are just rolling over in the face of the Carvel Corporation. And I'm appalled. I'm absolutely appalled.
I'll tell you what I'm appalled at.
Take your vote.
I'm appalled that these laws were jammed down the throats of people in spite of the turnout that I attended here. I objected to these laws myself in some detail.
There was
The hard look was never taken. The comp plan was shot down once in 2006 or 7. Went back to the judge in virtually the same form, shot down again. I'm appalled at that. I'm appalled
Are
at
you
the fact.
appalled at the judge or at us?
I'm appalled at the fact that no money was set aside in this budget by last year's board to fight this battle. And if not for the Greenway Compact, they'd all go down. I'm appalled by that. Last year with one lawsuit, this previous board spent $76,000. This year with 7 lawsuits, budgeted $63,000. The numbers don't add up. There's no way we could have fought this battle if not for the Greenway Compact. I'm appalled at that. I'm appalled at the irresponsibility of the former board not to take this obligation in hand. That's what I'm appalled at. We'll call the roll.
Can I just
Excuse
take,
me. Call the roll.
Excuse me.
no, if you
No.
can wait, we have,
No.
first of all, I need you to document for me the $76,000 was spent on one lawsuit. What was that
That's
spent?
not what I said.
What did
Sure
you
it is,
say?
Nick.
That's
That's
not
exactly what
Yes,
you
it is. I
said.
believe that's what was
One
reported in
lawsuit
the papers.
With
And
only
the
one
second-
lawsuit on its hands, the town spent a total of $76,000 on legal expenses last year.
But that $76,000 was $74,000, and that was legal expenses, and that's
And
non-litigation.
with 7 lawsuits to confront this year, the town board, having spent $76,000 last year on legal expenses, budgeted $63,000 this year.
There was not $76,000 of legal expenses for lawsuits last year.
I didn't say that.
Didn't come close.
I did not say that.
That's what was budgeted.
That's what was budgeted. And what was budgeted this year was $63,000 when we have 7 lawsuits to confront in addition to regular legal expenses.
We will inform the public of the actual numbers.
I'm sure you will.
At a later time.
I'm sure
This
you
is
will.
ridiculous.
I've heard numbers from 2,000 to now 76,000. I've seen no documentation. And I wish you could at least provide that for the board, if not for the public, because to just put that information out there without backing it up just seems very irresponsible to me.
We'll call the roll.
Excuse me, I'm still speaking. So we have maybe by our May meeting, you could provide us with documentation for any one of those numbers that you put out there in the public.
The $63,000 is part of the 2008 budget.
It's in the budget.
It's in the budget for
Cut and
this
dry.
year. I'm talking about
in the
the other numbers that you float, anywhere from $200,000 to tonight's $76,000.
No one mentioned
Excuse me,
$200,000.
David.
No, excuse me, you're saying we're mentioning
No, I am still
$200,000.
speaking.
Look.
Yeah.
What I'm asking for, whatever the number might be, is for documentation. I think it's rather irresponsible to just throw numbers out into the public, into the media, without any documentation.
Folks, let's
I
conclude.
find that irresponsible.
Let us conclude the town's business.
Can I move the previous question?
Second.
I didn't hear your motion.
I'd like to move the previous question.
Got a second? Let's call the roll.
Aye.
Wait a second.
On the previous question.
On the previous question.
And
Yes.
What's the
what is
previous
that
question
previous
exactly?
question?
The previous
To end
question
the
is
debate,
Pardon me?
to end the debate and vote.
go back to vote on the issue at hand.
The motion on the table is to vote to appeal wetlands for 1133 Conic or not.
So we have a motion to call the question.
Move the previous question.
Move the previous question, you voted yes?
Aye.
No.
No.
Yes.
Okay, so now we need to vote on the motion to appeal.
We have you moved the motion, Ross, and Diane, you seconded that motion?
That's correct.
That's correct. Call the roll.
No.
No.
Yes.
Yes.
No. Okay, we move to adjourn?
Second.
No.
No.
We need
No, we need to do the
Resolution.
Greenway project.
That's it. Okay. That's it.
I think that the resolution, there are 2 resolutions before you now.
Yeah.
Oh, yeah.
Given the vote, you're only working with one.
With the red one.
Right, the red
Cross out
one,
the other
I think we need to change the reference to related to the land laws and take out the freshwater wetlands language. On the,
Do we want to, let's just be sure, do we want to do that in light of the retrospective?
well,
Yeah, but how do you handle that?
yeah, because we're referencing a letter that was sent on the 23rd, which specifically requests application for retrospective and prospective
Right.
assistance. We're not changing the now therefore, which was hereby resolved to invoke the provisions of the environmental conservation laws outlined in the attached letter in connection with the rulings against the town.
Okay.
Okay, that doesn't change. The only thing that changes is the whereas Town of Mylan has authorized filing notice of appeal
Yep.
and a motion to stay the injunction with respect to the comprehensive plan. We need to take out that related language.
Okay.
think that's related,
Right.
just comprehensive plan.
Yeah.
And FLI.
That's
And
all
I was
right.
gonna say, add the one.
See, like, so let me get
All right, I'm going to read this resolution. Whereas Environmental Conservation Law, Article 44, established the Hudson River Valley Greenway to protect and enhance special places of scenic, cultural, and ecological importance, and whereas ECL 44-119 authorizes the creation of voluntary regional compact among the county, cities, towns, and villages of the Greenway to further the recommended criteria of the Greenway Council, and whereas the town of Island has adopted the Greenway Pact and is a Greenway Compact community, and whereas pursuant to ECL 44-010723, the Greenway Council is authorized to obtain insurance against liability of any participating community that may result from, among other things, its adoption or implementation of any land use control, and whereas pursuant to ECL 44-01197, the Greenway Council indemnifies any participating community in the event of legal actions brought against such community or its agents, resulting from, among other things, the adoption or implementation of any land use control, and whereas with the assistance of Greenway grants obtained pursuant to ECL on August 23, 2007, the town of Island adopted a revised comprehensive plan and related local land use laws entitled Elimination of the Floating Light Industrial Zone. And whereas the town has been sued by Red Wing Properties Incorporated with respect to the comprehensive plan and related local land use law, whereas in a decision Justice Brands dated March 24, 2008, Justice James V. Brands declared null and void the comprehensive plan and floating light industrial zone and issued a permanent injunction against the town enjoining the town from enforcing same. Whereas the town of Island has authorized filing of a notice of appeal and a motion to stay the injunction issued by the court with respect to the comprehensive plan and elimination of floating light industrial zone law. Whereas on April 23, 2008, Supervisor Richard Barrett and Town Board member Ross Williams submitted a written request to the Greenway Council invoking the applicable insurance and indemnification provisions of the law. Now therefore be it resolved that the Town Board of the Town of Island does hereby resolve to invoke the provisions of the Environmental Conservation Law as outlined in the attached letter from Supervisor Barrett and Board member Williams in connection with the rulings against the town in connection with the comprehensive plan and elimination of floating light industrial zone.
There a motion?
So moved.
Second.
Discussion? Call the roll.
Aye.
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 I move to adjourn the meeting.
You have a second? Yes, we do that. So we have a motion to adjourn.
Oh, yes, okay. I think we covered everything.
Second? All in favor?
Aye.
Aye.
Aye. Thank you, folks.